Okay, Charles, we have a good number of attendees that seem to have dropped in. So
excellent.
Pass over to you.
Shall I start then?
Yes, please.
So I hope you can all hear me and perhaps even see me and Emma. To introduce ourselves, my name is Charles Holbech, and I'm doing this webinar with Emma Loizou, and we're both from Radcliffe Chambers in Lincoln's Inn, which is a commercial and private client set of chambers, barristers' chambers. Both Emma and I specialise in contested probate work, and the intention is that we're going to give a talk today by reference to a hypothetical case study on challenging suspicious wills, and I'll explain what I mean by that in a moment. The anticipation is that it will last about an hour. If anybody wants to ask any questions, they can do so on the Q&A box, which I think Emma's going to deal with because I'm not technically savvy at all. So you've got, I believe, a text of the problem, and we also have some slides, which if we go on, we'll even set out the basic facts in a slide format. But by way of introduction, I thought I'd say a few words about what we mean by suspicious wills. There's a number of common features to probate claims when the validity of a will is challenged. Typically what happens is a testator executes a new will in favour of one or more family members, often to the exclusion of other family members. Or the will may be in favour of people such as friends, neighbours or carers. And that new will represents typically a significant departure from the terms of previous wills, which may have divided the testator's estate in a different way, such as equally between all the relatives. So the terms of the will are therefore surprising, or suspicious at least, to the parties who wish to challenge its validity. Often the testator is elderly, or was elderly, and or in failing health, perhaps in the early stages of dementia, or suffering the result of a recent bereavement. The golden rule, which is that any such will should be evidenced by a doctor who certifies capacity, may not have been observed, so there was no medical input. The testator is typically vulnerable and susceptible to influence, and the primary beneficiary under the will may have been in a position to influence the testator by virtue of their dominating personality or position of trust or their involvement in the preparation of the will. Usually there's little or no direct evidence that the beneficiary has sought to coerce the testator to execute the will, or there's been any fraudulent statement, but there is a strong suspicion on the part of the persons who wish to challenge the will that the testator was not actually aware or did not approve of the contents of the will as representing his or her wishes. A solicitor may or may not have been involved, and proper precautions may or may not have been taken. And that is the background to these sorts of claims. And there are a number of possible grounds of invalidity, such as undue influence, fraudulent calumny, want of knowledge and approval, testamentary incapacity, or lack of due execution, including forgery. Those claims interrelate with each other, but they are all legally different. And so one of the things that we're trying to do today is to go through the different requirements of each head of claim and apply it to the facts of our hypothetical case. I just say just a few words before we get on to the hypothetical case. There's a good quote from Lord Newburger and Gillan Woodall, where he says, wills frequently give rise to feelings of disappointment or worse on the part of relatives and other would-be beneficiaries. human nature being what it is, such people will often be able to find evidence or to persuade themselves that evidence exists, which shows that the will did not, could not, or was unlikely to represent the intention of the testatrix, or that the testatrix was in some way mentally affected so as to cast doubt on the will. If judges were too ready to accept such contentions, it would risk undermining what may be regarded as a fundamental principle of English law, namely that people should in general be free to leave their property as they choose. And it would run the danger of encouraging people to contest wills, which result in many estates being diminished by substantial legal costs. So we have to look at that as the background for these types of claims. Yes, very often people convince themselves that something untoward has gone on. But as also another judge has said in a particular case called Nesbitt and Nicholson, the problem in this case, as in so many, is that the parties seem to think that a judge can look into the hearts of the witnesses and somehow divine the truth. That's not how the system works. A judge can only find facts on the evidence properly adduced. I cannot tell what actually happened. I can only, as I have said, find facts on the evidence. So with that as a background, I think we'll turn, please, Emma, can we go on to the first slide and set out the facts of our hypothetical problem. I'm actually going to start at the bottom of the first slide because it goes sort of chronologically upwards. But anyway, we're talking about a woman called Lucy, I've called Lucy, who's got 3 children, Fred, Mark, and Helen. I'm going to the bottom of the slide. In 2019, Lucy had a major row with her son, Mark, principally over money. But they appear to have made up because in 2020, Lucy made a will that if she survived her husband, she divided her residuary estate amongst her 3 children in equal shares, absolutely. So Mark got a 3rd share under that. In March 2021, Lucy's husband of 40 years died, which, as we'll see, affected her deeply. So after that, she decides to make a new will in April 2021, and that provides for a gift of her holiday home subject to tax to Mark. She previously indicated that she wanted to give him her holiday home as he'd helped to locate it, spent some time there and expended some money on the property. And then she left her residuary estate, including her principal home where she lived, equally to Fred and Helen, her other 2 children. The net value of the holiday home after tax was about £150,000 less than half shares of residue. So Mark is effectively shortchanged and aggrieved by that because he doesn't get the same amount as his siblings, as was the case under the previous will. Can we go on to the next slide then, please? When Lucy executed the 2001 will, she was living at home. She'd suffered a stroke some years ago, but had made a partial recovery, but it had affected her speech and mobility. Otherwise, she suffered from a range of health problems, which I've listed there, such as diabetes, angina, depression, etc., and was in receipt of multiple medications. She was, as I said earlier, deeply affected by her husband's death, and in fact had been prescribed antidepressants for her low mood. And her health had, in the months leading up to her death, significantly deteriorated. In fact, she'd even been in hospital, but wasn't expected to die anytime soon. But despite all that, there was no specific record in her medical notes to say that she was suffering from any impairment of her brain, memory, or thinking. So her cognitive faculties, as far as the medical evidence is concerned, appeared to be intact. Can we go to the next slide? Yeah. The 2021 will, the last will, was prepared by a solicitor, Mr. Jones. who had been contacted by Fred, who you remember is Mark's brother. And Mr. Jones visited Lucy twice, first to take instructions and secondly to supervise execution. On the first occasion when the instructions were given, Fred was present, which he shouldn't really have been because he was a beneficiary under the will. Lucy told Mr. Jones that she was in poor health and grieving from the death of her husband, which had hit her very hard. She told him that she wanted to make equal provision for her 3 children, but was unsure how to do so, as Mark wanted to have the holiday home. Fred, not Lucy, produced a list of Lucy's assets and values of those assets to Mr. Jones, and Mr. Jones indicated that he could prepare a will so that the children were equally entitled, but that Mark received the holiday home on account of his 1/3 share. Lucy said that she would consider the matter further and get back to Mr. Jones in due course. The very next day, so very shortly thereafter, an email was received by Mr. Jones, purportedly from Lucy, from her email account, saying that she wanted to leave the holiday home to Mark, subject to tax, and the remainder of her estate to be divided equally between Fred and Helen. So that's, of course, a departure from what was being contemplated only the previous day and didn't amount to equal division of the estate. There are some medical notes on the same day of a visit by Lucy to her GP, in which she said that she was feeling tolerable and that after the death of her husband and due to her bad health, she felt, as she said it, all the stuffing had been knocked out of her and that she was very low. In any event, Mr. Jones on that day prepared a draft of the 2021 will in accordance with his emailed instructions, which, as I say, did not provide for equal division of the estate. On the second visit to supervise execution, Mr. Jones read the will to Lucy. Lucy, according to his note, indicated that she understood and approved its contents, and Mr. Jones recorded that he had no reason to doubt Lucy's testamentary capacity. But no doctor was called in to certify her capacity, even though she was elderly and suffering from poor health. Neither Lucy nor Fred, who was present initially on this occasion, told Mr. Jones that Lucy felt that all the stuffing had been knocked out of her. Mr. Jones did say to Lucy that Mark would or might end up with less than his siblings. He didn't put a figure on the disparity, and he didn't actually refer to the value of the holiday home. So there was no specific discussion. There was just a general, as it were, point being made that under the new instructions, Mark might end up, depending on values, with less than his siblings. And there was no specific discussion about the consequence of making the gift subject to or free from tax. Mr. Jones recorded in his attendance note that Lucy had told him that she appreciated that Mark might do worse than her other children, but that she was nonetheless content with that outcome, as she'd had problems with Mark in the past, and she sometimes doubted whether Mark really cared for her or only for her money. She said that Mark lived some distance away, that he hadn't visited her since her husband's funeral, but her 2 other children lived locally and had been on hand to support her. As far as execution was concerned, it was Mr. Jones and a trainee solicitor, and they both witnessed the will. The statements obtained from the trainee solicitor that he was in fact out of the room when the will was signed, executed by Lucy, but he'd come back in and then he'd added his signature as witness, having been asked to do so by Mr. Jones in the presence of Lucy, who raised no objection. Mr. Jones's evidence, on the other part, was that he followed his standard practice and that Lucy would have signed the will in the presence of both himself and his assistants, both present at the same time. Mark, who is, of course, unhappy with the outcome of the will, claims that he was prevented by Fred from visiting Lucy in the final months of her life leading up to the execution of the will, that he'd been threatened by Fred with physical assault if he sought to come anywhere near Lucy. Generally, he said that Fred was very domineering and that there had been a number of occasions in the past when he'd lost his temper with Lucy, and that Lucy was afraid of Fred. He also referred to a number of disparaging remarks by Fred to Lucy about Mark, to the effect that he was only interested in her money. And he also claimed that Lucy had forgotten that he'd incurred expenditure on improvements to the holiday home. So that is the background facts to the case. I hope people, you can all understand those facts. So what we then need to go on to is to look at the possible grounds of challenge to that will. And we were going to start, I think, with testamentary incapacity, which is usually the logical place to start, because if somebody's incapable of understanding the nature of a will and its consequences, then you need to go no further. So I was then going to hand over to Emma and ask her to go through the basic requirements for the validity of or invalidity of a will on the grounds of testamentary incapacity.
Thanks, Charles.
Yeah.
So the classic test of testamentary capacity is that set out in Banks and Goodfellow. So the testator must be capable of understanding the nature of her act, so executing the will and its effects, understanding the extent of the property of which she is disposing, comprehending and appreciating the claims to which she might give effect, and she must not be subject to any disorder of the mind as shall poison her affections, pervert her sense of right, or prevent the exercise of her natural faculties, and that no insane delusion shall influence her will in disposing of her property and bring about disposal of it, which, if the mind had been sound, would not have been made. And we know that this test survives the Mental Capacity Act 2005, most recently, as said, in Clitheroe and Bond. So that's the test at the moment for testamentary capacity. I think we're going to now look at some of the issues.
Yes, I might just interject that just a bit more on Banks and Goodfellow test. It's been made quite clear in the authorities that the court doesn't require a perfectly balanced mind. A sound and disposing mind and memory doesn't mean that the testator must possess those qualities in the highest degree, or as much as they had done in the past. So there is a degree of latitude about this. Somebody can be suffering, for instance, from moderate dementia, for instance, and still retain capacity. And it's also been pointed out that our general understanding of impaired mental capacity of adults has increased enormously since 1870, when Banks and Goodfellow was decided. It's now recognized that an adult with impaired mental capacity is capable of making decisions for themselves, given help. And of course, the issue of capacity is fact specific to the particular will. So if it's a very simple one, less capacity is required than if it's a more complex will. So back to you, Emma.
Thanks, Charles. So looking first at sort of some of the issues to consider, one of the main problems here is that we have medical records that don't record any impairment of Lucy's brain, memory or thinking, although we know there's been no formal assessment carried out as to her capacity. We also know that there's been a solicitor involved, an experienced and independent solicitor who's been satisfied as to Lucy's capacity. And in the case of Hawes and Burgess, the Court of Appeal said it's a very strong thing for a court to find that a testator lacked capacity when, for example, the will has been prepared by an experienced solicitor who's had a meeting with the testator. The will's then been executed after the solicitor's read and explained the will to the testator, that the solicitor then considers that the testator was capable of understanding the will, and the terms of the will appear to be rational on their face. And that's another point that we have here, which is that Lucy's instructions for why she changed her will don't appear to be rational on their face. She's given a plausible explanation for why she has decided to treat Mark less favourable than his other siblings, Helen and Fred. And she also approved that will once it had been read to her by Mr. Jones, and he was satisfied by her capacity. And the court in Hawes and Burgess suggested that a will executed in these sort of circumstances should only be set aside on the clearest evidence of lack of capacity.
So what would be the possible objections, though, or counter-arguments in favour of incapacity?
Well, I suppose here we have the fact that the evidence of Mr. Jones isn't necessarily conclusive. So any view that he's formed as to Lucy's capacity must be shown to be based on proper assessment and accurate information. And we know that he hasn't been told by Fred or Lucy that she had recently complained to her GP that all the stuffing had been knocked out of her. So that undermines his assessment of capacity. We also have the lack of the golden rule being observed. So in the case of an aged solicitor, aged testator, or one who has suffered an illness, serious illness, the will ought to be witnessed or approved by a medical practitioner who satisfies his or herself as to the capacity and understanding of the testator, and records and preserves this understanding. However, a failure, obviously, to follow this golden rule is not determinative of the lack of capacity, but clearly here, the absence of it may cast real doubt on Mr. Jones' assessment. And in these circumstances, we know that Mr. Jones is well aware that Lucy is fairly aged and she has poor health, and that she's been hit hard by the loss of her husband, which happened only a month ago from when she executes this will. But nonetheless, he decided not to take the additional precaution in those circumstances of obtaining medical evidence as to her capacity. We also have the effect of bereavement to consider. So in the case of Key and Key, the court accepted evidence that bereavement, especially in combination with other factors, may amount to a severe affective disorder, depriving a testator of testamentary capacity. So bereavement may affect the testator's powers of decision-making and comprehension. A person in that condition, suffering from bereavement, although they may have the capacity to understand what their property is and who their relatives and dependents are, might not have the mental energy to make any decisions of their own about whom to benefit. But then, on the contrary, bereavement doesn't always lead to the conclusion that the testator might lack capacity. So in another case, in Duramshi and Belgi, the testator made a will just about a month after the death of his wife, and the issue was whether the testator's powers of decision-making had been significantly impaired, such that he lacked testamentary capacity. And on the evidence, the testator knew what he was doing, what he wanted to achieve, and his thinking was not muddled or disjointed. He appeared to be fully in charge of his mental faculties.
What about sort of forgetfulness that, for instance, Lucy had forgotten that Mark had spent improvements on the holiday home, and maybe have forgotten other matters which might be relevant to a decision as to whether or not to benefit him, or to the extent that she wanted to benefit him?
So the forgetfulness may be evidence of incapacity to sort of comprehend the nature and the extent of Mark's claims, but capacity really depends on the potential to understand. It's not equated with a test of actual memory. So in Simon and Byford, Lord Justice Lewison drew a distinction between understanding the direct or immediate consequences, so what assets are at the testator's disposal and the person who claims on them, and the sort of collateral consequences of disposing them one way or another. And on the other hand, forgetfulness can be evidence of incapacity. So in Hughes and Hughes, the testator didn't have the capacity to appreciate the understanding he had with his son, that because his son had looked after stock and land for many years for no financial reward, and he'd made promises which would subsequently benefit his son and to his son's family, and he'd forgotten about those. But it wasn't just a case of forgetting a promise made or the provisions of his previous will.
Yes, that case is actually quite sort of relevant to our hypothetical case study, it seems to me, because the testator was suffering from moderately severe dementia and grieving from the death of one of their sons. And the court held that he didn't have the capacity to appreciate the understanding he'd had with another son over many years, during which that son looked after his stock and land for no financial reward, and then certain promises were made. And so that forgetfulness was held to be particularly relevant and to undermine the testator's capacity. Because what the deceased ended up doing was making a will which was in direct contravention of that previous understanding, favouring another son. So that is, I think, quite a pertinent case. And in this case, there was no specific discussion, was there, between Lucy and Mr. Jones as to the nature and value of her assets, nor as to the extent of the disparity between the value of Mark's entitlement as against that of his other siblings. Fred handed Mr. Jones a list and the valuation of Lucy's assets, and that wasn't specifically discussed with her. So there are, I think, things that can be said on incapacity to challenge this will.
Certainly, but and we might look at sort of some of the practical points as well, in terms of, but I don't know if you want to speak about the medical evidence and the impact that that might have.
Well, normally you would, of course, get evidence from an expert. The first port of call might be Lucy's GP, who'd seen her on the day before the execution of the will. And of course, the GP would at least say that she'd said that all her stuffing had been knocked out of her and that she felt very low and depressed, and might be able to say something about the prescription of antidepressants and her other health problems, and be able to produce a list of all the medication that she was on. But of course, a GP isn't a specialist in testamentary incapacity and may not be able to say an awful lot. And so it may therefore be necessary, in fact, it probably would be necessary for Mark to instruct a specialist on testamentary capacity to produce a report on the effect on her capacity of Lucy's bereavement, medical conditions, and medication. A degree of caution should always be exercised in this respect because, of course, the expert didn't have any personal contact, or doesn't usually have any personal contact with the testator when they were alive. And so the court may prefer the evidence, for instance, of the solicitor or of any other, as it were, lay witnesses, but it's nonetheless they will consider evidence of testamentary capacity from experts. It's quite an interesting case, a recent one called Re Clitheroe, where there was a disagreement between experts as to whether the testatrix was, by reason of her recent bereavement, rendered incapable of making a valid will. One expert said, yes, she was incapable, but she suffered from a complex grief reaction and a persisting depression, which was an affective disorder, i.e. something which was pathological or abnormal as a result of the death of her child. And so that supported the claim of incapacity. The other expert, because usually one will have two experts on either side, was more equivocal and said he couldn't say for certain whether or not there was an affective disorder, in part because there was insufficient clinical evidence in the medical notes. And the court held, in fact, that there was incapacity. They preferred the evidence of the expert who said that there was an affective disorder which affected capacity, making the point that the burden of proof is on those who want to uphold the will. So really, there is a significant doubt about capacity on the grounds of bereavement, then that may well lead to a conclusion of incapacity. Sometimes you get evidence from a single expert, as in the case of Hughes and Hughes, which is mentioned in the slides. Interestingly enough, in that case, the evidence from the single expert was in favor of capacity, but the court nonetheless rejected that evidence, partly because it was based on some flawed information coming from the GP, and it didn't have regard to all the witness evidence. But in that case, the court held that the testator was not, we've mentioned this before, capable of remembering promises made to one of his sons. And that led him to make a radically different will from the previous will. And it was accepted by the single expert that the testator was probably not able to remember their promises. So I think in conclusion from all that, there must be a real doubt as to Lucy's testamentary capacity. And that certainly would shift the evidential burden onto Fred and Helen to establish capacity. And ultimately, they had that legal burden in any event. And that real doubt arises, I think, out of the effect of her bereavement on top of all of the other evidence as to her bad health. And is exacerbated by the fact that there was a failure to follow the golden rule, evidence of forgetfulness, as well on the part of the testatrix. And so I think it must be an open issue to depend very much on the evidence as to whether Lucy had sufficient reserves of energy and focus, having regard to her bereavement and poor health, to make a valid will with full testamentary capacity. So that's, I think, what we'd say on capacity. Let's go on now to knowledge and approval. Do you want to take this, Emma?
Yes, of course, thanks. So it's a requirement to the validity of a will that the testator knew of and approved its contents. A will executed in ignorance or without acceptance of its contents are invalid. The question is whether the contents truly represented the testator's testimony intentions. And knowledge and approval must be proved in every case. Ordinarily, it will be inferred from the fact that the testator had capacity and the will was duly executed. However, where the circumstances are such as to arouse a suspicion of the court, the burden then falls on the propounder to actually prove knowledge and approval affirmatively.
The real issue, though, isn't it, Emma, is the involvement of the solicitor here who read the will to Lucy. It makes it very difficult, doesn't it, to say about a testator, assuming that they had capacity.
Yes.
To them, and they indicate that they agree with its contents. How then is it to be said that they didn't know of and approve the contents of the will? That's the That's the formidable objection here. And in fact, in Hughes and Pritchard, which we talked about earlier, or Hughes and Hughes, the will was not invalid due to want of knowledge and approval, even though there were suspicious circumstances, such as the fact that the son, who was the main beneficiary, was present when instructions were given in respect of the will, and that there were significant departures from the terms of previous wills. The will was a complex document written in English when the testator's first language was Welsh, but the court held that the draft will was read clause by clause to the testator before he signed it, which suggested that if he did have capacity, he would have known and approved of each clause in the will. But is there some other way, perhaps, that we could challenge the validity of the will on the grounds that the testator must not only know and approve of the contents of the will, but there's also authority that they must understand the effect of the will, perhaps?
Yes, that's right. So testator must also understand the effect of their will. For example, that a particular beneficiary is going to receive a very generous disposition in circumstances. So in Carapetto and Good, it was held to be necessary for the propounders of the will to show that the testator understood the effect of the will, and that was that the gift of the residuary estate included not just a house, but also an extra £450,000 after the incidence of inheritance tax. And in an appropriate case, a failure to actually appreciate the financial consequences of a testamentary gift, that's going to amount to a failure to understand the contents of the will containing such a gift. And we get that from Kinnicky and Hayward.
But what about the fact that Lucy was advised by Mr. Jones that the effect of the will would probably be that Mark might end up with less than his siblings, and that she appeared to accept this?
Yeah, I think that does undermine that to some extent. But we also have a number of other circumstances to consider, which could.
Of course, no precise figures were considered either. I mean, I suppose it's possible, isn't it, that she realised that he might end up with doing slightly worse than his siblings, but not necessarily aware that that might amount to £150,000 or something of that order worse than the siblings. And the solicitor didn't really drill down with her as to the extent of her understanding about those matters. So that, I think, may give some possible claim, although it would be difficult because it probably said that she understood the general effect or accepted it. But he should really have gone through it with her in much more detail and looked at some of the values to make sure that she did understand the effect or mark of this will, particularly when she'd given instructions only the day before, effectively for equal division, and this was going to lead to something which was not equal at all. Anyway, yes, I was saying there were other factors.
Oh, I think you've covered the sort of extent of the disparity wasn't ever explored, nor was it discussed with Lucy. We also have the sort of suspicious circumstances that her instructions changed within 24 hours. And those instructions resulted in the fact that Mark was then going to receive considerably less than his siblings. But those instructions didn't come from Lucy in person to Mr. Jones. They were sent by email, purportedly from Lucy, but they could have been composed and sent by Fred. He'd already played a significant part in procuring the execution of the will. It was him who knew Mr. Jones. He doesn't appear to have a good relationship with Mark. And Mr. Jones didn't then send Lucy a will to consider in advance of attending on her for the execution of that will.
Yes, and then we got the case of Mundell, Williams and Williams, which is quite interesting, where the testator originally gave some instructions, and he was subsequently contacted by telephone by a paralegal without appointment or warning, and then he gave different instructions. And the court came to the conclusion that he really didn't appreciate that the second lot of instructions which he gave was somewhat different from the first lot and had a completely different effect as far as the value of who got what in his estate, and wasn't satisfied that he intended to change his mind in that way. So that does go back to the failure of the solicitor, I think, properly to explore with Lucy, why she was changing and her mind, apparently, and the extent to which that might impact on the provision made for her 3 children, and in particular for Mark. What about bereavement? Does that have, Emma, do you think, some effect of this? We looked at that in the context of testamentary incapacity. Does it also mean, or could it mean, that if you are suffering from an affective disorder, you're not up, as it were, to the task of approving the contents and the effect of your will?
Yeah, so even if the court finds that Lucy did have a broad understanding of the effect of the 2021 will, it might still be invalid due to want of knowledge and approval by the fact that she was recently bereaved and the lack of energy that she may not have, as a result, applied her own decision-making and powers, and she may have been sort of acting as almost like a conduit for Fred. And in the case of Key and Key, there, due to the effects of the recent bereavement, the testator had not applied his own mind and decision-making powers in apparently agreeing that his daughter's assertion that his existing will was unfair, he should change it so as to leave the remaining property to his daughters. And knowledge and approval was therefore found by the court to be lacking. The judge there accepted medical evidence to the effect that distress caused by bereavement may make the sufferer suggestible and may make him say anything to put an end to emotional pressure.
And then it's often the case, isn't it, I think, that a want of knowledge and approval type claim can be a bit of a fallback when the court thinks really the will is very suspicious, unlikely to represent the wishes of the testator. You can't pin down any particular undue influence or fraudulent calumny. The testatrix was incapable, or they may be suffering from some sort of moderate form of dementia. But in all the circumstances, it seems most unlikely that they would have wanted the result which the will provides for. I mean, without going through the facts of Hawes and Burgess, but that effectively is what happened in that case. There was a choice there between testamentary incapacity, and the Court of Appeal said they would prefer not to decide it on that ground because the solicitor was involved, and it would be a strong thing to say the testator lacked capacity when an experienced solicitor was involved and satisfied as the capacity. But they really didn't like the result, which was effectively to cut out one of the testator's children. They thought it was most unlikely, really, that that would have been her intention. And then they fixed on 1 or 2 failures of the solicitor to take proper steps to bring home the contents of the will to the testator, such as sending her a draft of the will beforehand for her consideration, and decided that the burden really of satisfying the court that she knew and approved of the contents was not satisfied. So even at the end of all this, the court thinks that it is highly suspicious. It is possible that they would hold against it on this ground, but you do have the fundamental problem that there was a reading through of the will by the solicitor and a statement by Lucy that she understood that Mark might get less than the siblings. So I think it does make it quite difficult. As far as the bereavement is concerned, if bereavement does have the effect of, as it were, poleaxing her, then there's probably testamentary incapacity in any event. So why don't we go on to undue influence, Emma?
Yeah, so it's very difficult to establish undue influence in the context of a will, and this is largely because it requires actual coercion, so the improper exertion of influence over a person. to execute a will that's actually contrary to their wishes. And there must be positive proof of coercion that overpowers the volition of the testator. The words used in the authorities are victimization, domination, and coercion. So persuasion without more is not coercion. And undue influence doesn't just extend to sort of physical violence, it extends to verbal bullying, or simply talking to a will or a weak or ill person in such a way that person may be induced for quietness' sake to do anything. So a drip approach may be highly effective in sapping the will. So the physical and mental strength of the testator is a relevant factor. The will of a weak and ill person may be more easily overborne. In terms of the elements that have to be established, the claimant must establish either by way of proof or inference, opportunity to exercise influence, the actual exercise of influence, and that actual exercise has to be in relation to the will. The influence has to be undue, as I've said, so it's beyond persuasion, and the will has to be brought about by those means.
So what about the, on the facts of this case? I mean, the problem is, isn't there, as is often the way, there's no direct evidence of coercion in the sense that you were talking about, forcing somebody to do something they wouldn't otherwise do. I mean, all we know, don't we, is that he's a domineering sort of character, and it's alleged that his mother sometimes was afraid of him, and he made some unpleasant remarks, perhaps, or threatening remarks to Mark. Does that amount to sufficient evidence of coercion of Lucy to make a will that she didn't want to do? That's the issue, isn't it, Emma?
Yeah, I think so. And I think the difficulty here as well is that there's a plausible alternative explanation for this will. So that Lucy was upset by previous conduct by Mark, and that she was only that he was only interested in her money. So I think the sort of this part is going to be more difficult, and we may have to look at the inferring.
Well, it is the case, isn't it, that you've got it here on the slide, that you can, in some cases, infer undue influence from sort of circumstantial evidence, because you're usually not going to find a letter, are you, from the alleged influencer saying, unless you change your will, you're never going to see your grandchildren. It's all going to be circumstantial. But what you do need, don't you, sometimes described in the authorities as cogent evidence, and sometimes it's said, well, if there is an alternative plausible hypothesis to what went on, then there isn't sufficiently cogent evidence. The case of Hughes and Hughes, which we've referred to a few times before, is interesting on this. The court said, although there was evidence that the son sought to persuade his father to change his will in his favor, there's a distinction between legitimate persuasion and coercion. And there was a plausible hypothesis as to why the father might have wanted to have changed his will in the way that he did. And so the undue influence claim was rejected. And I think that does, show how difficult sometimes it is to get an undue influence claim off the ground. Sometimes you're almost forced to do that because the want of knowledge and approval claim may be shut out by the fact that a solicitor has been involved and has read through the terms of the will and explained the terms of the will to the testator. It may not be possible to rely on that, and your best case may well be that even though they knew what was in the will, it didn't actually represent their true wishes. They were acting under undue influence. But as I say, the evidential difficulties are formidable, although there are cases such as Schrader and Schrader, which you've mentioned there, where there was, in fact, a finding of undue influence. But all the evidence really pointed one way in that case. So that, I think, is the difficulty on undue influence, although it has to be said, it's pretty remarkable, isn't it, that Lucy should have instructed the solicitor on one day that she wanted to make equal provision for her children and then abruptly changed her mind within a day in circumstances where Fred was sort of on the scene and in a position to influence. So, I mean, you wouldn't necessarily write off undue influence. It might depend upon all sorts of other evidence and all sorts of other witnesses as to, the extent of her influence and what they witnessed, etc. But as I say, usually it's going to be pretty difficult. What about fraudulent calumny, Lucy?
So the basic idea with fraudulent calumny is that a person is poisoning the testator's mind against another who would be a natural beneficiary of that testator's bounty. And they do that by casting dishonest aspersions on their character. So it's all about poisoning the testator's mind. And in Kinnicky and Kinnicky, the court identified the following elements, so that there's a false representation to the testator about the character of an existing or potential beneficiary, and that's done for the purpose of inducing the testator to alter her testamentary disposition, and that's with the knowledge that a representation is untrue or recklessness as to its truth, and there's the added factor of causation. So the disputed will is only made because of the fraudulent calumny. So here we have evidence that Fred had told Lucy Mark was only interested in her money, and Lucy then repeated that to the solicitor, to Mr. Jones, when justifying the inequality that prejudiced Mark.
The question is whether or not then, Fred dishonestly implanted that notion in her head, and that caused her to change her will. As we can see from this slide, it would have to be said that any statement made by Fred that Mark was only interested in her money was false. Well, arguably it wasn't false. Maybe he was only interested in her money. That Fred made the statement with knowledge that it was untrue or recklessly disregarding its truth when he may well have believed it quite genuinely. It was made with the purpose of inducing Lucy to alter her will. I mean, he might say, well, I might have made the odd derogatory remark about my brother, but I wasn't trying to change her will. And that she, in consequence, was induced to change her will. I mean, maybe she exercised her own free will in making a decision about that matter. So it is quite difficult for us to make out a case of fraudulent calumny, although it's not impossible, and there have been cases when that's happened. More likely to occur, I think, if there's a more specific representation, the falsity of which is much more obviously provable. So if, for instance, Fred said that Mark had stolen money from Lucy when he hadn't, and she'd got that in her head, it was pretty clear where she must have got that from, then that would be different. And then due execution, Lucy. Emma, sorry.
Yes, I think we've just got time to do due execution. Under Section 9 of the Wills Act 1837, that deals with the formalities for making a will. So no will shall be valid unless it's in writing, signed by the testator or by some other person in his or her presence and by his or her direction. It appears the testator intended by the signature to give effect to the will, and the signature is made or acknowledged by the testator in the presence of two or more witnesses who are present at the same time, and each witness either attests and signs a will or acknowledges signature in the presence of the testator, but not necessarily in the presence of any other witness, and no form of attestation shall be necessary. So that's Section 9. So there are a couple of issues to consider with due execution, because obviously we have the trainee's evidence that if it were accepted, he says that he didn't sign the 2021 will was not signed in the presence of both the trainee and Mr. Jones. So that would seem to suggest that the will had not been validly executed, given Section 9.
Yeah, but what about the presumption of undue, of due execution? That's pretty strong, isn't it? And you've got the evidence of the solicitor that he thought it was properly executed. And there is an attestation clause in the will, which would suggest that it was properly executed. So do you think that the court might come to the conclusion that whatever the trainee may have said, maybe his memory was at fault or something of that nature, and that the will was properly executed and that it was signed by the testator in the presence of both witnesses.
Yes, exactly. And in the case of Kentfield and Wright, this was the position, and the will was regular in its face. It contained an attestation clause saying that it had been signed in the presence of two witnesses, and the court therefore said the strongest evidence is required to rebut the presumption of due execution. And one of the witnesses, like the trainee, gave evidence that the other witness wasn't present when the deceased signed the will. The other witness didn't recall the details, but insisted they wouldn't have signed it unless the deceased had signed in the presence of both of them. And the court said the evidence wasn't sufficiently strong to rebut the presumption of due execution. On the basis of the evidence, it seemed that both witnesses were present when the deceased wrote and signed the will, and both signed it at the same time in the deceased's presence. So the court might prefer Mr. Jones' evidence that the 2021 will was properly executed on the basis that both witnesses were present when the will was signed.
What about, isn't there an alternative argument as well, which was that Lucy may have acknowledged her signature in the presence of both witnesses when, if the trainee was out of the room and then came back again and then was asked by Mr. Jones to sign in front of Lucy, who sort of made no objection and appeared to agree to that. Is that an acknowledgement potentially of her signature?
Yes, so an acknowledgement can be by gestures, by the little of a nod of the head. So,
I mean, I think it's the case, isn't it, that a witness is asked to sign a document by somebody in the presence and hearing of the testator and sees or has the opportunity of seeing the signature. That's a valid acknowledgement by the testator, even though the testator doesn't actually say, you know, this is my signature. It's implied. And if that's the case, they were both there at that point. And so she would have acknowledged her signature effectively to both of them. So that may be an argument. So possibly the grounds of want of due execution may not be one that's going to go too far. So in conclusion, what do we think possibly are the best claims? I think we say that due execution is a difficult one for the reasons I've just explained. Fraudulent calumny is always difficult, and there are all sorts of hurdles to overcome there, such as proving Fred's dishonesty, that he actually made a statement that has influenced the testatrix. Undue influence is a difficult one, despite the change in the testatrix's intentions, moving away from the principle of equality, because it's very difficult to prove when there's an alternative hypothesis. Want of knowledge and approval may have a little bit more mileage, but faces the difficulty that there was a solicitor involved who read the will to her and did explain to her that it might end up with inequality, and she seemed to accept that. Although there are odd circumstances, and maybe she didn't understand the full effect of the new will, but probably the best argument I would have thought would be on the basis of testamentary incapacity, although of course you would need expert evidence, I think, to support that claim. But if she genuinely was completely knocked sideways by the death of her husband, all the stuffing knocked out of her, depression, etc., other medical issues, maybe her medication might have had some effect on her. The fact that she's changed her will, within this, effectively her instructions within 24 hours, and there hasn't been a full and proper discussion, maybe I think that the court might hold that the burden of proving capacity has not been met. So I think that would be my possible conclusion. But you can see how all these different claims interrelate with each other. It's about the hour up, isn't it?
Yeah, I think so. We've overrun slightly. Thank you very much for joining us today for the first part of these workshops. Right, thank you very much for joining us.